After you've submitted a Metlife disability appeal that's governed by ERISA, which is what 95% of the claims are they sell, and most of the claims that we see for Metlife, the only remedy that you have at that point in time is to file a lawsuit. And that lawsuit has to be in federal court because this policy is governed by ERISA, and we're going to talk about that. Now, we're going to talk about the pros and the cons of ERISA, more cons than pros. But when you think about a lawsuit, and the person who's watching this video now has basically just been denied, and they found us, YouTube, Google, whatever, and they're like, let me hear what this law firm has to say. What should I expect? And I know before we're going to get into this about what to expect, they're going to be surprised. Because lawsuits in the world of ERISA, whether it's Metlife or anybody, are not the lawsuits that they see on TV. It's not the trials that we see when they're going on, when you're getting that I got you moment with the witness, or you get to cross-examine somebody, or you get this great opening argument. It's a totally different animal. So Frank, talk about what goes on in an ERISA lawsuit and why it's so completely different than anything a person would expect.
First of all, pick a lawyer that your carrier respects. And by respect, I don't mean somebody who just, has a few cases or 20 or 30 cases, but has a body of work that says to the carrier that you'll take a case to the mat, you'll litigate to conclusion, sickness or an injury. If you think fibromyalgia has been wrongfully denied across the country, or chronic fatigue, or, right now we've got long COVID. Some carriers have taken a hard position on long COVID. We're litigating those cases, and carriers respect us. Why? Because we're bigger than any other plaintiff firm. We've got more horsepower in terms of lawyers. Second, we are filing our cases. And I tell my insureds, look, after we've done a terrific appeal, the carrier can make the wrong decision and deny. Doesn't mean they're getting off the hook with us. We're going to file the complaint. We're going to look at the federal judge, who, by the way, is appointed for life by the president. So Republican, Democrat, we've got to look at that judge's history, and we do. Also, we're going to look at outside counsel. Who are we litigating against? They're going to deeply respect us. They don't want to get tagged with a wrong decision or a case that affects sickness across the United States. Fibromyalgia, is it a self-reported complaint and sickness? Well, what if we take that issue on across the country, and we have? So carrier's going to look at that. Next, when we file the complaint, for the insured, the risk at that point is small. And small, I say, in terms of time, because they're not getting deposed. There's no witnesses they have to come to trial. They don't have to pay their treating doctor the half day to come and testify in court, because there's no testimony in a federal ERISA case. And there's an opportunity to resolve the case. Carriers respect us. They know we can win cases we were supposed to lose, and they're going to lose cases they were supposed to win, which means it's a good opportunity to resolve cases as long as you're reasonable. And for us, we're dealing at the highest levels of the company. I'm not dealing with, local counsel. I'm dealing with national trial counsel at Metlife to be able to be in the right place to get the right number for the insured. So I always say to the insured, once you get to the lawsuit stage, now it's time to sit back and let your spectacular lawyer go get your money.
That's a great synopsis of what a claimant should expect when they're going to hire us and get us on board with the claim. But Rachel, I want you to talk about the technical aspects of, when you're going to go forward with this case. Let's assume it's not something that's going to resolve before a trial. What does the judge have to do? What is the claimant wants to know and should understand, because it's not a jury who's looking at this, and I want you to talk about that, but how is this case going to be reviewed? Who's making the decision? What does that person who's making the decision, what standards do they have to apply in order to determine if Metlife was wrong, or if the claim should be reversed, or if the claimant should get paid?
Right, and in most cases, it's an arbitrary and capricious standard of review, which means that we have to prove that the insurance carrier did not have even one reasonable basis to deny the claim. And like we discussed earlier on, the judge is looking only at the administrative record. So it's an administrative record, which is going to contain anything that went into the appeal that our firm may have or may not have filed, anything that's in the file that the insurance carrier has from previous when the claimant was on claim. All of that gets reviewed by the judge, and then our motion, whether it's summary judgment motion, is also reviewed, but there's no testimony. So the judge is looking at what's already in the claim file, what we're arguing, and they're determining whether the insurance carrier had a reasonable basis to deny. And it's a very difficult standard to get past. It's, was there a reasonable basis? A lot of things can be deemed a reasonable basis. So the insurance carrier can go and hire a doctor who they pay to just do a paper review, who cherry-picked records, who just, made a decision that, hey, this claimant may have had 9 doctors who said they can't work. But our one doctor who reviewed the records for 20 minutes decided that they disagree with the claimant's treating physicians, and we believe that he's not disabled. And a judge can determine that that's a reasonable basis for denial, unfortunately. It doesn't seem like a fair basis, but it can be deemed a reasonable basis. So that is one of the ways that a judge looks at these cases. So it's our job to try and prove that there was not a reasonable basis, but it's a hard standard. It's a hard hurdle to get over.
Dumb it down even more for somebody. What is physically going to the judge? Are you showing up in court and telling the judge? I mean, dumb it down so the claim, because there is a lot of work that goes into before you get to the judge, and I want a claimant to understand what are they getting out of their lawyer. Walk them through it, because you've been through it many times.
Right. Well, we're filing a complaint, so it's a lawsuit that has to be very detailed about why it is that we're suing the insurance carrier, why we're suing Metlife, and why we believe that there wasn't a reasonable basis and why we should have our claim overturned. We are providing that service in preparing this lawsuit. We are also reviewing the administrative record. We're preparing a very detailed motion for summary judgment, usually, where we're going to be arguing our points and a lot of case law that we're familiar with that we've collected over the years, and all the new case law that comes out that is favorable to our client. So all of that goes into our motion. And no, we do not get to most of the time argue in front of a judge. I have done oral argument in federal court. It's rare. Most of the time the judge is just reviewing our motion, reviewing the giant administrative record, and rendering a decision. And they don't get to meet the clients. And that's even something that my clients are very confused about. Well, the judge is going to see me and they're going to see how sick I am. No, they don't get to meet the client, unfortunately. They don't get, your doctors don't get deposed. They don't get to get on the stand and testify on your behalf. So whatever's already in that record is what they're relying upon. But assuming that you had a very strong appeal and everything was put in there that that we think is very important to win your case, that's what the judge will base the decision on, and hopefully that will win your case.
So, Frank, when people understand the judge is going to get these motions, and these are limited to 25 or 30 pages depending upon the jurisdiction, and then there's a reply, and there's another 10 or 15 pages, and then sometimes there's another reply. So the judge basically has 40 pages of briefs written from the plaintiff side and the defense side. And in these briefs is when lawyers really become lawyers in terms of, in ERISA, having to have the knowledge of all of these cases. And what I want you to talk about is, I call ERISA the wild, wild west. Explain why it is in the world of ERISA, why it's the wild, wild west, and why that could work to the advantage of a claimant, or maybe the disadvantage of a claimant based upon where the case law is.
Such a good question. We've done thousands and thousands and thousands of these cases. And if you jump out of the airplane the same way every time, pretty soon the other side gets a pretty good idea of how you're going to present your case and what you're going to say in this circumstance or not. I always like to think outside the box, because we have the wherewithal. We can get the very best doctors. We can go get the chair of the Department of Orthopedics in the city or the state where that insured is. We can get the preeminent doctor to talk about the neuropsych issues or what have you. We get great vocational doctors to be able to put a terrific, terrific report in. We get declarations from before and after witnesses to talk about, hey, when Greg was working, he had a zealous attitude. There's no financial gain here. We get the doctors to do bulletproof reports, going through the objective, then going through the subjective. And then we get the wife, the husband, the kids, the neighbors, the co-employees to be able to talk. We get to create, and you always use the example of painting. You know, when you have the wherewithal and you have more experience than anybody, it gives you the opportunity to sit back and paint a masterpiece. And that's our job for these insureds. They don't have the money. They don't have the wherewithal. They don't have the ability to be able to deal with a federal court situation. And by the way, Greg, nobody litigates in federal court. It is a very isolated area of the law. If you're not in a bank robbery or some kind of federal crime, you know, you're not in federal court. ERISA takes lawyers to federal court. You know, you better have a long, steeped history in terms of federal court experience to be able to deal with a judge that's appointed for life by the president. And in these cases, I always tell the insured, you've got a federal judge and there's 5 clerks that are all lined up at a table on the other side. They're 21 to 24 years old. They're there for a year to help the judge go through the evidence, because this judge isn't going through 5,000 pages. We better write, and we better give some life experience to 21-year-olds. They're not used to the kind of sickness and problems that our insureds have. So we better write to them and then know what the federal judge is like. Like I said at the beginning, you hire a spectacular lawyer.
Well, Rachel, as you know, and we have people at our firm who do nothing but case law research. There are thousands and thousands of cases that have been decided in the world of ERISA. And for every argument where we come up with something and we find 5 cases that support us, the defense is likely going to come back with 5 cases that were decided by 5 different judges, and they complete different sides of the fence, right? So having a good lawyer requires you to know the latest and greatest case law of a world that's always constantly evolving. Every day we get notifications of a new ERISA decision that came out there. And if you don't have a law firm that knows the ins and outs of that, you're going to get buried, because the defense lawyers on the other side, they're doing this every single day. You can't be going with a law firm that, you know, does Social Security work or personal injury work and doesn't day in, day out do this kind of stuff, knows the case law, and is putting in the latest decisions, even the judge's own decisions. Judge, you decided this way in these 4 other cases. And if you're going up against, whoever the disability company is, you better know to say, hey, this is how Metlife did everything in every other one of their cases, Judge. They've already been told 20 times that this is unreasonable conduct, Judge. They can't do that. They know, because how many cases have there been against Metlife? Thousands. So you just find all their stuff and you present it. But I want to, we gave people a flavor of this is what's going on, and it's a lot, and it requires, and it's very boring for them, but we enjoy it, we thrive on it, and we put them in the best light possible, and if we do their appeal, we take everything that you said, Fred, because now they got a great appeal, and now it's easy for us to say all the stuff they didn't do and make their witnesses look horrible, very weak, and say, Judge, you got to believe these top people that we had. But Rachel, talk about the remedies. And by remedies, I mean, what do you get when you win? Because we win 99% of our cases, but a win doesn't just mean we get the judge to go our way. As a matter of fact, as you know, most of these cases don't go to the judge making a decision, yet we still consider that a win. So what are the win options?
There's many win options. So I always explain to my clients, because they're completely unfamiliar with this federal court procedure and how it works, and even what they can win. They'll come to me and say, well, my claim is worth $1 million. So if I go to federal court and I win, I'm going to get $1 million. And I say, unfortunately, I wish you would get $1 million, but it doesn't work like that. So I explain to my clients that if we do win in our best day in court and a judge finds that Metlife was arbitrary and capricious and denied the claim unreasonably, then they can award your back benefits that they already owe you to date. So they're going to say, okay, Metlife, you have to pay them the $50,000 they owe them in back pay. And at that point, since we're the prevailing party, we can also file a motion for attorney's fees and costs. We can win on that, which, could be $10,000, $20,000, whatever that may be.
Hundreds of thousands.
It depends how long you spent on trying the case. Those are remedies that a judge is permitted. Then he can remand your case back to Metlife. So if he finds Metlife was unreasonable, they got to pay you the past benefits they owe you to date. Now they got to review your claim again to determine, are you disabled currently going forward? And
so the judge can give them another bite at the apple.
Absolutely. another bite at the apple so that they can say no. They can say yes, but they also can say no, and then you're back in the situation where the claimant's having to file another appeal and go through this whole thing again, and this could go on for years. So this is a potential outcome of winning a case in federal court. Another way to actually win a case is to settle the case and to come to an amicable settlement, which, I explain to my clients also is not getting every penny that they owe you to age 65 or 67, but it's going to be some sort of reasonable amount that both sides agree to at the end of the day, that, neither side's going to be so thrilled about, but at the end of the day is fair. And that is also a win because, assuming we worked up your case, if we worked up your case and we knew what to put in your file, that makes your settlement value, skyrocket.
Significantly more.
Absolutely. If you come to us and, you didn't file an appeal with us, somebody else did it, we don't really have a lot of support, it may make the settlement value lower, but we're still very experienced and we can still get a good settlement for this claimant.
So what I tell claimants when they call us, send us your final denial letter, we'll review it, we'll review your policy. We'll determine what we think is the value of the claim. I mean, we've done this so much that we can look at it and say, hey, we have to take a deep dive into the claim file to see what they did, to say what do we think are the chances of win. But we know the value of the claim right away. And based upon even just looking at their medical support or looking at the denial letter, I know I usually can give a preliminary opinion and say, hey, I think that this is a winnable case. If it is winnable, I think it's going to be worth at least X amount of dollars, because some people are like, hey, they want to know right away, is this $10,000? Is this $300,000? Where's the range going to be? And we're not going to blow smoke. I can't stand the other people out there who are like, this is a winner no matter what. We're going to get you every single dollar that you're entitled to. These are hard cases, and there's a lot of risk. But if we can get a decent amount of money on the table, now I'm going to say to you, here's $100,000. Do you want to risk or invest $100,000 in this to maybe get $200,000 over the next 15 years? It's up to you. If you do, we're along for the ride. No problem at all. But if you don't, here's some certainty. So our job is to get the best available options for the claimants. If we can win the case, amazing. We'd love to. If we can get you a settlement, that's a win too. Most importantly, we want you to walk away with money. And we want you to get what you're owed and as much money as possible. So,
and by the way, when you file that case in federal court, first thing the carrier is going to do is they're going to look at your lawyer and they're going to assess, has that lawyer gotten an hourly fee in a federal court case that's gone to judgment? Is it $400 an hour? Is it $600 an hour? Is it $1,100 an hour? The carrier on the other side doesn't want me involved in a case at 100 hours of my time at $1,100 an hour.
right.
That's an incentive for that carrier to step in early, mediate the case, and pay the insured the money that they should deserve. So when I said earlier about your lawyer, ask a little bit about their hourly that they've been awarded in a federal court ERISA case.
That's a fantastic point. So I encourage people to contact any of us, send us your denial letter. We're always going to provide you with a free initial consultation. No matter where you live in the country, we're available to assist you, and we'll let you know immediately if we can help you with your Metlife long-term disability denial.